everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. So these are the articles that we will be discussing upon today. The first one is Victory in a Long Battle for Equal Opportunities. So here we have almost discussed this article before as well, but since it has been taken up again in the Hindu, which talks about the granting of permanent commission to women in the combat forces or the combat roles in the armed forces, that has been discussed. Secondly, A Unity of Purpose, which is from the Indian Express. This basically talks about the recent clash that has taken place in the Parliamentary Committee for IT, which is Information and Technology. We'll be discussing that in detail and as to what are the parliamentary committees. Third, what are question R, zero R. So this is from the explained section of the Indian Express, and it is a very important concept, and we belonging to the law background or even as general citizens also should know that what actually is the question R and what is the zero R, as they are very important in the entire functioning of the parliament. And fourthly, OBC subcategorization findings progress by panel so far. Now, as recently we discussed about the pondering upon of subcategorization in the SC and ST. So this subcategorization in OBC, which already exists, has been discussed. And fifthly, news and flash, which is important for our crisp pointers, which are specifically more important for a prelims exam. Before that, let's have a look at the LawSikho courses that we have for you. So here we have the Judiciary Test Prep course, which is the lot of the courses. The link is there in the description box. You can definitely have a look at it if you want to avail this coaching and a course for judicial services preparation. There itself, you'll be able to find this free study material, which is really nicely drafted for all judicial services aspirants. Then we have various other courses also. They can anytime be looked at the LawSikho website. With this, let's see that what is the MCQ for the day. Mission Karma Yogi is related to first, defense services, second, naval services, third, permanent commission to women in armed forces, or fourth, civil services. Now let's just do an exercise that all of you, if you can guess the answer to this question, jot it down in the comment section and let's see that whatever you have been able to guess, is it right or not in the further slides to come. Now this is the descriptive question for you all. Discuss the merits and demerits of granting permanent commission to women in the armed forces. Is it a right step to the direction of equality? So the entire thing has to be discussed about the permanent commission and what are the pros and cons and whether this is a leading step in the direction of granting equality to the society. The answer to this question has to be written within a word limit of 250 to 300 words, which can be jotted down in the comment section below as well. With this, let's quickly start with the Permanent Commission for Women, which says that the Supreme Court, as we had already mentioned it in our previous sessions, that it was in the case of the Secretary, Ministry of Defense versus Babita Punia and others, which is a very recent case of 2020, February 17th itself. It allowed women to serve as permanently commissioned officers in the Indian Army. So until this judgment had arrived, the women definitely, they were granted or they were allowed to have roles in the armed forces, but they did not have the right to be permanently commissioned. That was till the age of retirement. That was the jobs, the roles that they had were not permanent in nature. But now, after this landmark, judgment, this permanent commissioning of women officers in army is possible. Now, July 2020, the government issued a formal sanction. So this is a small timeline as to how these events have taken place over the years, and this shows the long struggle that the women have done in order to achieve this. Great success in this area. So it was in 1992 when for the first time Indian Armed Forces began to induct they began to induct women in non-medical branches such as the SSC officer. Then in 2006, the initial 5-year scheme of SEC was revised to 14 years. So it was further increased to 14 years. Then in 2010, in the case of Jasmine Kaur versus Union of India, Delhi High Court allowed permanent commission to women in the Indian Air Force. So please keep in mind that this one has made it, further extended this permanent commission to the Indian Army. Earlier it was there, but it was in the Indian Air Force. So Indian Air Force allowed permanent commission to the women, and that is why it was appealed later on for to be granted in the Army as well. Also, here is a small fact for you all that even till date, the largest number of women that are serving amongst all the three forces, that is the Navy, the Indian Air Force, and as well as the Indian Army, Indian Air Force has the highest number of women, which is approximately to 13 to 14%, whereas in the Indian Army, it still is only about 2 to 3%, which is very less, but we really hope to increase that with this landmark judgment. And then in 2020, so, this judgment arrived. Now let's see that what are the implications or the impact of this judgment. So women are now entitled to serve till the age of retirement. That exactly is the meaning of permanent commission. And secondly, now women officers can be considered for command roles and career postings as well. Basically, by command roles, we mean that they can have an upgraded version of post as well. Now, since because they are eligible for the permanent commission as well. And other employee benefits such as in-service career courses, Defense Services Staff College, options in higher studies, pension, and ex-serviceman status shall be provided to the women as well. And this will definitely mitigate the shortage of officers currently, which is only 18% of authorized strength. That is also in totality. Please keep in mind it is in totality. And amongst all the forces, only 18% are the women officers. And thus, now it will definitely mitigate the shortage of the officers. And one thing that needs to be seen is that even the combat role is changing these days. So it is not just that one has to be on the border to save the country or so. The innovation and also the introduction of technology has changed this entire scenario, and that is why it is a golden chance that this time we have also given this equal chance to the women to be a part of these forces. And this is the way forward, that terms of employment of SSC are subject to change, and SSC basically is the short service commission. So now they'll be granted permanent commission, but till date they were working as only in the short service commission. They're subject to change, and conversion into the permanent commission are faced on force requirements, and no provision for women to choose defense as long-term career right at the outset as the PC officer. So basically, this is a really good step that has been taken in this direction, and we should definitely look forward to such more judgments and such more enhancements in the social order of India. Then next is the topic which talks about the parliamentary committees. Now, why at all this topic is in news is firstly that there has been an open confrontation. That means in a way we can say a kind of a verbal conflict that has arisen between the chairman of the IT committee, who is Shashi Tharoor, and a senior BJP member of the committee, Nishikant Dubey, has raised concerns regarding the convention of the parliamentary committees. So basically, the main question of dispute here is that whether the chairman, who in this case is Shashi Tharoor, has the right to call an official from Facebook as a witness. So recently there has been a tussle between both of them, because Shashi Tharoor is of the view that he would be calling us an official from the Facebook to be a witness regarding actually there was this entire issue going on wherein Facebook was being a bit of, it was blamed by the Indian leaders that it is not showing the data or the entire thing in an unbiased manner, and also it was favoring some of the other people, and the content that was going on the Facebook was not filtered properly. So these have been all the issues of the IT parliamentary committee, and that is why Shashi Tharoor wanted to call one of the officials from Facebook itself to be the witness. But here Nishikant Dubey, who is another member from the committee, he says that this should not be allowed. Now, whether the question here mainly is about the selection or bringing in of the witness as to who decides it. But before that, we need to understand as to what is a parliamentary committee. This is a very potential question if we talk about mains. Parliamentary committees, the questions regarding them have been very, highly, it's a high chance that a question from these may arise. So we should know that as per the constitution, it is a committee which is appointed or elected. So please keep in mind, parliamentary committee is appointed, and it may also be elected by the house or the nominated by the speaker or the chairman. It works under the direction of the speaker or the chairman. So a prelims question also may arise that whether it works under the direction of a speaker or a chairman. So keep in mind that it works under the direction of both the speaker or the chairman. Presents its reports to the house or the speaker or the chairman. Has a secretariat, please mind it is secretariat provided by the Lok Sabha and Rajya Sabha. Then there are two types of parliamentary committees. One is a standing committee and the other is an ad hoc committee. Basically, standing committee these are permanent in nature, and they are though revised from time to time, but they are still permanent in nature. Whereas ad hoc committees are the ones that are implemented or that are brought into picture for specific functions, and once that is achieved, they are dissolved. And also, they are comprised of parliamentarians who function on a non-party basis. Now, the very point here that says that the chairman of the IT committee is Shashi Tharoor, and as we know, he belongs to Congress, whereas the other one is a BJP member. Who is Nishikant Dubey. So basically here you don't have to be, it is nothing like the ruling party, the members from the ruling party can only be the members of the parliamentary committee. Basically, this is only the one of the most unique features of a parliamentary committee, that it is totally on a non-party basis. This actually ensures that there is no biasness in the functioning of parliamentary committee, because obviously if the members, all of them, would be coming up from the ruling party itself, then definitely they would not be questioning the government at all, and there will be, the functioning also will be in a biased manner. But because here a heterogeneous formula is used, and also it is made sure that the members of this parliamentary committee are not ministers, that is, which means that they are not serving a particular role in the government at that point of time. So they are created by houses of parliament to scrutinize the governmental actions, and they make recommendations to the government which are directory in nature, which means that the government pays a lot of heed to whatever these parliamentary committees are giving as their own suggestions or recommendations. Now, is there any law related to the list of witnesses? Now, this is the main issue as to who decides that in a particular situation, who can be the witness, and who actually has the discretion to decide that who can be a witness. So basically, there is no specific rule defining the right of the chairman to call a witness, and the names of the witness are prepared by the secretariat, approved by the chairman with modifications if required. So basically, there is no specific rule as to who does it, but yes, in general times it is done by the secretariat, and then it has to be approved by the chairman, and the chairman can also make required changes to it. Then rule 270 of the rules of procedure says that decision of the speaker will be final if question arises as to the relevancy of the witness. So let's see that what do we have to see in this particular case as well. Now for the next topic, we have the question hour and the 0 hour. Now this you must have heard it several times. You also read it in the newspaper that this actually this issue was raised in the question hour. And even if you tend to watch the Lok Sabha TV or the Rajya Sabha TV, so there also, where the live proceedings of the parliament they are telecasted, there also this question hour and 0 hour comes to the to be seen. So recently, the Lok Sabha and Rajya Sabha secretariats notified that there will be no question hour during the monsoon session of Parliament, and 0 hour will be restricted in both the houses. So this actually has raised a lot of concerns in the minds of the member of parliaments who are from the opposition, because we'll also see it in detail as to how, but 0 hour and question hour both are to say, the remedies which are provided to the MPs belonging especially to the opposite party other than the ruling party, because this is when they have a chance to question the government or put forward their concerns regarding any steps taken by the government or any policies which are brought by the government. Let's see that what is the question hour. Basically, question hour is 1 hour, which currently in today's convention is from 11 a.m. to 12 p.m., where members ask questions. Now, as the name itself says, they ask questions to ministers, holding them accountable. So if, any step has been taken by a particular minister, so in this question hour, anybody, any of the members can raise a question regarding anything from any minister, and then he would be accountable for that. Then questions are designed to elicit information and trigger suitable action. So, it might also be done to bring in the attention of the speaker towards any particular issue that is going on. And the significance mainly is that in the past, they have exposed financial irregularities and brought transparency in the government functioning, because obviously this is, in a way, we can say, a right to information, which has a further extension in the face of question hour. So if there is any confusion, if they want any clarification, or they want to question any of the ministers, the MPs can put up their question in the question hour, and then they can make the ministers accountable for any kind of financial irregularity that they might be doing, or any kind of opaque activities that are going on. So thus they are very, very helpful in bringing in the transparency and accountability in the governance system. Now, the session without question hour, winter session in 1962. So after the Chinese aggression took place, so it was the only time in 1962 when we did not have a question hour in the session. Otherwise, we have always had a question hour, and this would be the first time after such a long time that we would not have a question hour. Then what is 0 hour? So the concept started in the first decade of Indian Parliament. We can definitely give credit to ourselves for this, because 0 hour is something that has been innovated and brought in by the Indian system of governance itself. We have not really taken it from anywhere, but rather it is our own invention. So it was done and was started in the first decade of the Indian Parliament, when members could raise important issues without an advance notice. So many a time, so basically, generally they have to give notice regarding any discussion that they want to bring into the discussion of the Parliament. But if it is done in the 0 hour, then this advance notice is not really required, because there are many times some issues that are of very prime importance, and the person or the member who raised this issue did not really have this reasonable time to put up this advance notice, and that is why even if it is of so much importance, it is allowed in the 0 hour even without an advance notice. And this also is not a part of the rule book. So as we know that this is one of the parts of our convention, so you will basically not be able to find any particular provision related to the 0 hour, but it is more of like a convention that we follow in a parliamentary system. Now lastly, we're talking about the Commission for Subcategorizing the OBC. Now, as very recently we got to know that the SCs and STs, they're also are trying and thinking upon this idea of subcategorizing the scheduled castes and scheduled tribes for proper percolation of the schemes and policies of the government and providing the equality in the real sense. We also, while discussing this topic, had discussed that the OBC, which are the other backward classes, they already have this subcategorization. If you remember, we have this creamy layer which exists in the OBC. So that is why the provisions for them are different, and for the other classes that are there in the OBC are different. So here, this small analysis has been done as to how much has this been successful, because obviously, if we are trying to take a similar step in the other two areas of SC and ST, we should definitely be analyzing that what has been the success rate of doing this similar step in the case of OBCs as well. So basically, it was the Commission for Subcategorization of OBC has been examining the same for almost 3 years now. So its tenure has now been extended to 2021, but it was appointed in 2017, and the commission is headed by retired Delhi High Court Chief Justice G. Rohini. Basically, we must see that what this commission was given the task to do. So firstly, it had to examine the extent of inequitable distribution of reservation policy benefits. Basically, they had to understand that how much and or to what extent the distribution of the reservation policies has been distorted or has been done in an unequal manner. So according to that, only the steps could have been taken. Secondly, work at a mechanism, criteria, norms, and parameters for subcategorization. Thirdly, identify the castes and communities and classify them into subcategories, because obviously if we have categorized some particular class of the people as a creamy layer, some study must have been done in order to reach out to that result. And fourthly, study various entries in the central list of OBC and recommend the corrections. Now let's see that what has been the analysis of this commission and what have they actually analyzed. So this analysis they did in the year of 2018. According to this analysis, 97% of jobs and educational seats went to 25% of OBCs. So basically, we know that the criteria that has been provided for OBCs is 27% of the jobs would be provided in the government sector to the OBCs. And out of them, 97% of the jobs and educational seats went to 25% of OBCs. So which means that out of all OBCs, only 25% of them, that maybe, according to us, who we can call as the creamy layer or the people who were more privileged to get these jobs, 97% of jobs were and education seats were availed by them itself. And we can see that in this also 75% of the OBCs still remained, they were still not made available with these opportunities. Then 37% of total OBC community have zero representation in jobs and educational institutions, which is bizarre, because obviously if you're trying to give reservation to a particular community to come at par with the other sections of the society, then you should make sure that that community should be treated or should be given such treatment that all members of that community can uplift themselves. But still we see that 37% of these OBC community also have got zero representation in the jobs and educational institutions. And then 994 OBC subcastes have only 2.68% representation in recruitment and admissions. So still here we can say that it is amongst the OBCs also the privileged ones who are availing these benefits given by the government, and we still have the oppressed sections that are not getting the required benefits. So the OBC recruitment in central jobs is that as per the 2018-19 annual report of the Department of Personnel and Training, OBC representation it's very meager. See, only 13.101% in Group A jobs, and in the Group B jobs only 14%, and 22.65% only in the Group C jobs. So all in all, we can categorize, and we can also understand that even after provision of this reservation system, and even after subcategorization of the OBCs, this entire aim of bringing all of the people at an equal level has not been achieved considerably. So according to the RTI based report in the Indian Express, no professor and associate professor appointed under the OBC quota in central universities is there, which is really something that we should think upon, that in any central university, even a single professor or associate professor comes from the OBC quota. So with this, let's see that what do we have for news in flash. Mission Karma Yogi. Now here you might get the answer for your MCQ for the day. Union Cabinet cleared major changes in the way civil services officers will be trained and skilled across the country. So basically, Mission Karma Yogi is related to the civil servants in India. Under the program, 4 entities will be established, namely Prime Minister's Public Human Resources Council, secondly, a Capacity Building Commission, third, a Special Purpose Vehicle, and fourth, a Coordination Unit, which should be headed by the Cabinet Secretary. So basically, what is Mission Karma Yogi and what is it related to should be kept in mind. Secondly, Union Cabinet approves Jammu Kashmir Official Languages Bill 2020. So this is really important, as this has approved to introduce Hindi, Kashmiri and Dogri as the official languages in addition to Urdu and English. So till date, Urdu and English were the official languages over there, but now it has also decided to add Hindi, Kashmiri and Dogri. Dogri is a language which is primarily spoken in the areas of Jammu, and Kashmiri is one that is spoken in the valley, that is in the hilly areas of Kashmir. So now these will be added as the official languages in the Jammu and Kashmir. Third, Global Innovation Index 2020. So this Global Innovation Index is compiled by WIPO, which is the World Intellectual Property Organization, in coordination with Cornell University and INSEAD Business School. And this is really something to celebrate this, that because India, it jumped to 48th positions out of 131 economies, and Switzerland bagged the first position, followed by Sweden, USA, UK and Netherlands. And fourthly, RA as reserve forest. The government of Maharashtra has announced, you must be remembering that RA forest, there was a huge protest coming from the civilians and people who were living in the areas near the RA forest, because it had to be cut down for some industrial or some construction purpose. But the common people that lived nearby to this forest, they actually came upon the streets and they made sure that this forest is not felled, which is such a good step that the societies have taken. And now the government of Maharashtra has announced the reservation of 600 acres of RA land near Sanjay Gandhi National Park as a reserve forest. And with this, it is the first instance of an extensive forest blooming within the limits of metropolis in the world to be declared as a reserve forest. So it would be for the first time that in a metropolis city like that of, it is in Mumbai actually. So in a metro city, this huge, extensive, dense forest would be there as a reserve forest in the middle of this metropolis city. So with this, we are done for the day. We hope it was a good and informative session for you all. Stay tuned with LawSikho for such more sessions to come. Thank you so much.